up. So I think it's very nice that consultation room is having all these things, because generally we feel that, oh, if we are first generation, if we come from middle class families, there's no hope for us. But I think Hari sir is a sterling example, and if I can say so.
I think I'm just
Okay.
Hello. Good afternoon, everybody. Today is the fourth session of our consultancy room lawyers, and I will be first requesting our guest of this evening, Mr. Sudhanshu Paro, Advocate General in Supreme Court. I will be requesting that he will be coming to this side.
Look at me, I directly came and sat.
And
That's what your confidence.
Arun Devanji. And I will be requesting. And we all are today very much, and I can say that everybody was enthusiastic to hear also the senior advocates of our Delhi High Court. One amongst them is Nandita Raoji, who has got a good standing in the criminal side, as all of us. So, give her a big hand also again. And I am sorry to say, in fact, the keynote speaker, Mr. Hariharan's daughter-in-law, I understand she was not well for quite a long time, and now I have received a message that she passed away. So Hariharan sir has left from Delhi to his native place. So in any case, we will be also praying God for a heavenly abode, and we will start the program in a normal course. So I will be requesting all of us, if we can have a prayer for 1 second. Everybody can stand and now we'll be starting with today's program. So let me just introduce our organization. We all are the lawyers, those who are practicing in Delhi High Court, and either it's a good or in a normal course. Some of us, since are young also, they do not have the chambers, but as per our Delhi High Court provisions also, the lawyers can use the consultancy room. The younger generations, they often use the consultancy room. We all also start our practice from that consultancy room, and we have a good group also. So everybody, now we have got a better accommodation also, apart from the consultancy room which was in the old building, Chamber Block 1. But now in S Block also we have got 5 rooms, but 3 rooms are ready. So from May onwards we are organizing the regular weekly legal discussions, debate, as well as the regular lecture series, we can say that. Today is the 4th lecture series of our consultancy room lawyers. First we had organized on section 34 of arbitration. Then from arbitration we came to this criminal appeal. Thereafter the regular fast appeal. Now today we are in criminal writ petition. In our organization we are all, the hand in hand we are doing it. With me, Mr. K.K. Singh is also there. I am Prashant Verma. Mr. K.K. Singh is with me. Mr. Naveen is also with us. And Nandita Rao Junior, The junior says also the same,
So
Nandita.
nice to meet you.
And
I've seen your name in the list. I was wondering कि भाई कौन है name से. Very nice to meet you.
another Sudhir is also today not here. He has gone out of Delhi. But any case, we all are in hand, we are organizing it, and we also would request the younger generation people, lawyers, they must also join with us, either as a speaker, normal advocate, as well as when they will become senior also, they will be also going to, with us as a senior advocate. But in any case, so our aim is to have a harmonious relationship with our senior advocates of this campus, with that of the younger generations, young lawyers. We have to learn many things from our senior advocates. At the same time, while doing many matters, we are also having good number of experiences to share with the younger generation, as well as it's not that the younger generation, every day we used to learn also. There are different topics, there are different subjects. We have in our consultancy group of people, we had discussed that we will start with all these nomenclatures like, the writ petitions, then regular past appeal, then CSOS. In those manner only we will be starting. Thereafter on different subjects also, in a specific subject also, we will be dealing with that. So without taking lot of your time, so now I will request Mr. K.K. Singh to conduct today's meeting. Mr. K.K. Singh.
मेरा सभी लोगों को नमस्कार. All the my respected seniors, members, and my friends and people. तो इसमें नंबर 4 3 सीरीज हमारी कंप्लीट हो गई हैं. फर्स्ट की सेक्शन 34 एप्लीकेशन, सेकंड हमारी क्रिमिनल अपील, और थर्ड रेगुलर फर्स्ट. एंड द फोर today's will start criminal writ petitions. Today's कि जो आज हमारे स्पीकर्स हैं, बहुत रिस्पेक्टफुली और सभी लोगों ने हमारा बहुत साथ दिया, और उम्मीद करता हूँ आगे भी इसी तरीके से हमारा मुझे साथ मिलता रहेगा, और आप सब लोग इसी तरीके से टाइम टू टाइम हमें ज्वाइन करते रहेंगे. सो लेट्स स्टार्ट. फर्स्ट स्पीकर अरुण धवन सर, आप इनके लिए प्लीज.
You can address while sitting, or you need to stand for that?
No, you can sit.
Yes, yeah, thank you. It's not required, I think.
Not required.
Everybody is
Not required.
voice is audible to everyone.
No, it is not audible. That is the reason why. Because when we are recording, it is also having the YouTube channel also. So people also are using, or they can at a later point of time see. That's the reason I was key.
So, good evening, everyone. My name is Arun Himan, and I am practicing in Delhi High Court, Supreme Court, or even trial courts also, district courts. So, today's topic is criminal writ petitions, basically in High Court only, because in Supreme Court we have 32, but in High Court we generally file writ petitions under 2 to 6. So, just a small, I am here just to give an introduction, because ma'am is there to give things in brief. So, I'll try my level best, whatever best I know.
I'm also here to learn. We are all learning.
Yes. So, as you all know, that writs are of 5 types, like habeas corpus, that is for basically, and then mandamus and certiorari, cohibitio and quo warranto. So, generally we have seen that most of, when we were in early practicing age, so we see that habeas corpus is something where we need to file when we need some illegal detention is there. Then in that case we go for habeas corpus. But when we go through and when we pass with the practice era, then we find that even all the writs are compulsory for initiating criminal trials in the court, in High Court. So habeas corpus is basically for illegal detention. It can be filed by the victim or the family members, or by the person who has been illegally detained, or who has an apprehension that the authorities can illegally detain him. So these are the circumstances when habeas corpus can be filed. Then mandamus is there. It is basically for against the authorities tell them that they have to do certain acts or some deeds so that they can enforce, it can be enforced basically. Proviso is to restrain them to do something, and certiorari in this is and co-warranto basically. So I'm coming to that step by step. So who can file criminal writ in High Court? So who can file basically? This is the biggest question, and who can approach the Honorable High Court? So the first is the victim himself, the aggrieved person, family members of the aggrieved person, and the foreign citizen or OCIs also. They can also come when there is a question of the right to life and personal liberty is at stake. Basically, they can come. So then, when it can be filed, basically, so it can be filed when where the alternate remedy is ineffective, basically. What are the alternate remedies? Like revision, appeals under 482. Now it is 531 in BNSS. So these are the alternate remedies. So when these alternate remedies are ineffective, in that case we can come in 226 before the Honorable High Court. Then the second is where there is a violation of fundamental rights. And the third is when substantial question of constitutional interpretation arise demanding authoritative resolutions. So these are the things when we can approach to the Honorable High Court. So there are basically Mr. Prasanta has told me that I have to tell few judgments over that. What are the judgments where we can, the Honorable Supreme Court has said that these are the points when we can approach to the Honorable High Court. So there are a number of judgments. If all of you can note down or anyone can note down, they can have. That's why I have prepared the notes. So this is MP State Agro Industries Development Corporation versus Jahan Khan. This judgment is of 2007, and then Whirlpool India Limited of 1996, then Sara Ali Khan versus State of Haryana, and PHR Invent Education Society versus UCO Bank of 2024. So what these judgments says, that the test held by the Honorable Supreme Court, that when someone can approach the Honorable High Court for filing of criminal writ under 226. So when there is a violation of fundamental rights, then they can come. Then when violations of potential law is challenged, basically. So when principle of natural justice is violated, and when impugned order is without jurisdiction. So these are the 4 points when we can approach to the Honorable High Court for filing seeking remedy under 226. So these are the points. So now that I am giving you few examples that when the Honorable High Court has taken a cognizance under 226 and passed some important decisions and directions to the authorities. So like, as you all know that anti-Sikh riots were there in 1984. So during that time the Honorable Court has passed order under writ of certiorari, wherein they have quashed closure reports filed by the authorities. That closure reports were filed by the few perpetrators, and when the Honorable High Court has seen that the police has malafidely quashed, given closure reports to them, so Honorable Court quashed those closure reports and asked to set up an SIT, and this Nanavati Commission was also set up to conduct further investigation in 1984 Sikh riots. So thereafter, in 2002, Gujarat riots also, habeas corpus was the Honorable Court passed order under habeas corpus, and Bilkis Bano and 14 other victims, they were asked to produce before the court for record their statement, and on their statement, proceedings can be initiated. And then in 2023 Manipur violence also, around 2,000 missing personnel were located, and mandamus orders were ordered to set up an SIT. So these are the few examples when the Honorable High Court and the Supreme Court also intervened in writ jurisdiction and passed orders against the authorities and even to the lower trial courts or the lower courts, so that appropriate proceedings can be initiated. And then what is the purpose of the writ jurisdiction? Basically, the only, what I have read, the only purpose of this of the writ jurisdiction is to enforce fundamental right and to protect the legal rights of the individuals, basically. So this is basically the few, a small glimpse. So I just have 10 minutes. So in 10 minutes, whatever best I can tell, that I have done. Now I am just forwarding this.
But I must say, Mr. Lehman has highlighted a very nice thing. I don't know आप लोगों ने notice किया that he first pointed out habeas corpus, which we use most commonly, everybody knows. But then he went to the issue of Bilkis Bano, Manipur and 84 riots, where the High Court normally, if closure report is bad, what does the High Court tell us? Protest petition में जाइए. However, where there is such widespread glaring breakdown of the rule of law, in those cases, the High Court has made an exception and not told the individual victims. I mean, even I had not thought of this. So he has highlighted that in certain circumstances where the fundamental rights have not been violated of an individual, but a group or a huge, Hanuman, please come. So, I commend Mr. Dhiman on a very concise, very precise, and I hope you all have taken note, because violation of fundamental rights is ongoing. In my...
I request Rita to
No, ma'am, we are not. Please join us. In fact, my senior from Suryan Company, ma'am, is also here.
Please. America.
All my civil law I learned from ma'am and Sita after so long. It's so nice to see all the colleagues over here. Wonderful initiatives. Sorry to make it a discussion, but I feel we are all lawyers. So, it's not a bookish thing. We are all at the same level. And I must commend Mr. Dhiman that he has brought to your notice that individual violation of fundamental right and a community or a section of people's violation of fundamental rights, the role of the High Court becomes different. So the High Court has discretion. You can't be myopic. Where like 500 people's rights are being violated, the High Court can't say, no, all of you go over there. Then what's the purpose of the High Court? If rule of law, so I found that to be a very thoughtful inclusion. I had not thought of it myself.
Thank you.
Sorry for speaking too much. Next time you won't invite me.
Thank you, Mr. Lehman, and
Thank you, अरुण देवन साहब. आपने हम सब लोगों का बड़ा अच्छे से मार्गदर्शन किया और मैं उम्मीद करूँगा कि नेक्स्ट टाइम भी आए और हमारा हम सब लोगों का हौसला बढ़ाएं. और इसी क्रम में मैं सुधांशु पालो साहब को रिक्वेस्ट करता हूँ कि प्लीज आए और रिट पिटीशन पे.
Thank you very much to the organizing committee for giving me this opportunity to speak few words on the topic of criminal jurisdiction of Delhi High Court. Let me say first that if we analyze the meaning of it, where it came from, why it is, what is the necessity of it, we will not go through of it, but I can say that if you find the Black Law Dictionary, the meaning of writ is a written order, a command to a person or a legal authority to do something or a friend to do something. But we are here to analyze the jurisdiction of the High Court under 226. Why the criminal jurisdiction? Every High Court having the same power under 226, Article 226, exercise its statutory jurisdiction to give directions under certain risks. I number of risks are there. Habeas corpus, mandamus, co-warranto, prohibition, etc. Now, I can say you that the jurisdiction is not a substitute procedure of statutory procedure. The High Court only can entertain a writ petition under special and exceptional circumstances. Why it is so? Because it is a discretionary nature. I will give you two examples. I have come through. One writ petition I filed in Bombay High Court one educated old lady came to me. She said that my daughter has been dated illegally by a man who is a married man, and he is not allowing me to enter his house to meet her daughter. And she made a lot of complaints to police and DCP concerns, Superintendent of Police concern. They didn't do any action. Even those Director of State Police also, Commissioner of Police also. Thereafter, we filed a petition in High Court in Bombay. Initially, I said that let the body, that victim should be present before the court. Court was directed to the DCP concern to produce the lady. She came into the court. The police officer produced that lady. But I said, I requested the court, I want to a camera hearing. Because the old lady, the mother of the victim, she said that the person who has detained that lady, they are transporting ladies to Dubai. So, then the judge agreed and took us to the examiner. I am in love with that man. I have no problem. I will remain with him. Then it is a situation that the mother of the lady said that her daughter has been detained and enforcement forcefully has kept and she is not been allowed to meet her. But this victim is saying that I am in love with him and I want to stay with him. I said he is married man. And how is she said that the person, she said that I am not married. Later on I found that this old lady has kept 50 lakhs rupees in his account, in her account. So she wants that 50 lakhs should come to that mother. That is not, that would not happen. So sometimes you have to see how the jurisdiction, why it is not a substitute procedure of statutory law. One has to grant his grievances through statutory provision only. When one approaches a police fails to do so, then the procedure that earlier it was 150/60 and CRPC, now 175 at BNSS. Thereafter, if the police also, if the registration offer is not, your purpose is not fulfilled, then you can go for the 200 CRPC. At present now 180 of the BNSS. I may say that before filing a petition, writ petition, there are certain aspects we have to look into. What are those aspects? First is territorial jurisdiction. Where we have to file a petition? Where we have to file a petition, we have to analyze it, that where the cause of action arose and where the occurrence has been committed. We have to see it first. And we have to gather information and documents also. For documentation is required. Court fees is required according to the respective high courts. Thereafter, the process fee is required. Hearing that according to every high court, the rules is there, how we will file, what are the procedures required to be filed, you have to follow it. Now, another example I will say, that I filed a petition writ petition crossing an FIR here in Delhi High Court against a POCSO case. That it was a dispute between wife and husband. There is a daughter of a husband. She was with the husband. When the brother of brother-in-law came to meet the brother-in-law, there is a fight. The daughter is with the husband. What she made a complaint before police station that my uncles, they outraged my modesty. She was, I think, 9th class student, and police registered in a POCSO case against her. When I filed a crossing petition here, Honorable Justice Mukta Gupta is there, she said that there are certain procedures has not been followed and an FIR has been registered. She directed the police to DCP to inquire into the matter. Thereafter, I later on find that the investigation officer was in trouble and he faced some criminal proceeding. There are some guidelines which has not been followed. So we have to be very careful while we are filing a writ petitions. Though it is an extraordinary decision of High Court. Because somebody may abuse it. And it's a jurisdiction the High Court can pass to secure and serve justice, and where the justice has been delayed and the High Court also generally they do not interfere when a statutory authority has passed orders under legislation, unless there is a grave error, unless there is a malified intention has been manifestly reflected in the orders. Because sometimes we file a tribunal's order challenging under statutory, then only High Court interfere when they manifestly see that an act and an order has been passed without having jurisdiction of the court below or tribunals. So, I may say here that the jurisdiction exercised under Article 226 by the High Court is only under exceptional circumstances, because it is a discretion in nature. They will not entertain it, otherwise it will be an open box. Everybody can. At first, you redress your grievances in the statutory authority, under the statutory authority, when the law has been prescribed to grant your grievances. If it failed to do so, or they failed to do so in accordance with the law, they have malified intention, thereafter you will only should approach the High Court. Thank you very much.
Thank you, Sudhanshu Kalu sahab. I'm very happy all of them. Sir, के लिए I'm request to please. And I request to Rita Police.
मेरे को तो कुछ पता नहीं है, मैं
I'm request, please, few words.
What a coincidence, sorry.
Your explain, you say your explain.
अभी तो आप ऐसे मेरे को बोल रहे हो.
I'm requesting.
आप बात के लिए करो, ऐसे काम के ऊपर भी तो बोल सकते हैं.
क्या बोलूँ मैं? Good evening to everybody. Just I was passing from this because my chamber is there. I just had a meeting with my client. उसको मैं बाहर तक नहीं देखा यहाँ पे मैंने कहा देख तो लो क्या हो रहा.
कल बात हुई थी.
Yesterday we informed you.
बात हुई थी but I had no idea. कि हमने casually बोला मैं भी casually चली गई. तो it is very nice कि चलो इस block में we have these small rooms. At least on the first floor we have 3 rooms.
Yes.
And दो इस side है, दो एक उस side है. So I am in between. तो बहुत अच्छा है. ऊपर वाले 4 floors में only one room consultation is there, but mostly the rush is on this floor. और the staff is also very good जो भी है. And apart from this, that कि कल हमारी casually बात हुई क्या हो रहा है, I don't know even what is the topic. But इतना थोड़ा सा समझ आया कि there is a jurisdiction point पे कुछ बात हो रही है, right? कुछ यही है ना? Jurisdiction पे बात.
Criminal rate के.
तो मैं इतना ही कहूँगी यहाँ पे जो भी यंगस्टर है जो भी है and because I had since 90 I am here. So जितना आप I will not go on this क्योंकि ये हमारे सारे पढ़े लिखे बैठे हैं. इन्होंने मैं वही बोलूँगी जो इन्होंने बोल दिया. But apart from this, what I would suggest everybody, please go through very quick. आपको वो बोलने का मौका ही नहीं देते. आप खड़े हो जाओ, वो कहेंगे you answer for this point. मतलब आप रात को पूरे पढ़ते जाओ. एक पॉइंट अगर कहीं पे भी छूट गया, he will tell you that point only. मैंने ये देखा है, my experience with my life. Yes, since 90 you can say I was also very, you know, अभी ऐसे ही जाते थे. मगर अभी before हम we should open our mouth. अच्छा, you answer this point. और अगर आपने वो छूट गया तो आप हके वके रहोगे. आप चाहे कितना भी बोलो, जज उसी पे अटका रहेगा. क्योंकि this high court I have seen इज वेरी ब्रिलियंट, इतना मतलब मैं क्या बताऊं, यहाँ की एक्सपीरियंस की जो हमने वकील वो कहीं भी नहीं एडजस्ट कर सकती। आई हैव बीन टू, मैं आपको थोड़ी अपनी एक्सपीरियंस लाइफ की बताती हूँ। अपार्ट फ्रॉम दिस, बिकॉज आई वाज गोइंग टू द शिमला हाई कोर्ट, वहाँ पे वो मिस्टर जोसेफ थे तब, देयर आई यूज्ड टू अपियर। इलाहाबाद हाई कोर्ट में तो बहुत ही, मे भी आज तो शायद ठीक हुआ होगा, आई डोंट नो, पर आई हैव
It's very good, very high caliber and
अब
high skills.
आप आज की बात बता रहे हैं ना, मैं तो 90s की तो 2000 की बात बता रही हूँ। मैं तो नोएडा के केसेस में ही जाती थी जहाँ पे उन्होंने कैंसिलेशन ऑफ प्लॉट्स किया था। यू विल नॉट बिलीव, एज अ लॉयर आई वाज वन ऑफ देम, एंड फिर मैंने कहा चलो मैं भी जाके देखती हूँ। अब गए हमारे बीजी सीनियर एडवोकेट हमने किया था, सॉरी मैं दोनों लैंग्वेज यूज कर रही हूँ, वहाँ पे हमारे थे केस त्रिपाठी, I think so, he was that time senior advocate there, तो हमने उसको भी कर लिया। जब it was a land issue, वो cancellation हुई थी, so I also went, I said let me go, and you will not believe, it was an urgent matter, हमने फाइल किया कि अब कल सुबह hearing पे आएगा। 1 week I had to stay there in the hotel, till तब भी नहीं आया, मतलब आज जैसे मंडे है ना, सैटरडे तक मैं वहीं थी। Then it was not teaching. मैडम आ जाएगा, मैं क्लर्क को पूछूं, मैडम आ जाएगा, अरे क्या हुआ? फिर त्रिपाठी जी को बोला, अब जिसने एक पहले गई तो जिस हियरिंग पे आया तो आई ऑल्सो गॉट अप, तो मैं खड़ी हो गई, तो जज ऐसे देख रहा है, whom you are appearing, this Tripathi, the senior advocate, he did not turn up. When he did not turn up, so what I should do? I was representing the society. न वकील आया न वो आया, तो मैं खड़ी हो गई, तो मेरे को कहा, oh, the respondents are no, we are the petitioners are two, this that you have come from Delhi. मैंने कहा no, I am one of the petitioners, but the Mr. Senior is coming, तो उसने डेट लगा दी। देखो गुस्सा तो आया, मैंने कहा इसको मैं फीस भी दे दी, लेकिन तो आए नहीं, तो मैं गई उसके ऑफिस में, मैंने कहा सर आप आए नहीं, सीनियर एडवोकेट, कोर्ट सीनियर का लगा हुआ है, और मेरी इतनी हिम्मत की मैं खड़ी हो गई, डांट, मतलब वो बोला तो मैंने बोल दिया, तो then they did not say, I am one of the petitioners. मैं कहते हैं जी, मैंने उसको क्लर्क को बोला, मैंने कहा he did not, क्या हुआ? कहते हैं जी आपको नहीं पता, ये जज के पास कोई नहीं पेश होता। मैंने कहा what? कहता हाँ, ये तो डांट देता है। मैंने कहा मैं तो, हम तो दिल्ली से हैं, हम तो रोज ही ऐसे जज देखते हैं, हमको तो कोई फर्क नहीं पड़ता। That was the kind of which I have faced. You will not believe. Next time I went, I had to stay in the hotel for 6-7 days. Still I did not get a stay order or whatever order. Then that clerk told me, madam, please you go, we will send you the order or jo bhi. This is the kind of high court we have here, and I have experience with the other court. That day I did not go there. So मेरे कहने का मतलब इतना है कि जितनी आप मेहनत करोगे, जितना आप डीप प्रोफेशन में जाओगे, जितना एक एक पॉइंट लोगे, वो आपके काम आएगा। And do yourself hard work. Read one by one. See what documents you have to place. नहीं है उसको कहीं से लेके आओ. Because only then from here you will get all the relief what you want, and you can fight for the justice or whom you are giving the justice. Otherwise, यहाँ के हमारे जैसा हम तो 40 साल से यहाँ जजेस को देख रहे हैं, and be precise with your briefing. जितना आप 100 पेज का लिखोगे ना, judge is not going to understand. I don't know कि आप फर्क पड़ा है, तब तो कहते हैं what is this senior school? What is this 100 page? Give me 4 pages, 5 pages. What is your case? So you have to work and you have to take experience with each and every one. जितना भी हो सके, जितना मतलब ये है, and कोशिश करो खुद भी पेश हो जाने की। मैं सबसे कोशिश करती हूँ कि you also try to appear before the judge. He will not, if अगर कहीं गलती हो जाएगी तो वो आपको encourage करेगा। ऐसा नहीं कि यहाँ के judges encourage नहीं करते। So I request everybody, जो भी starters आते हैं, please go and appear before judges. 2 बारी 3 बारी पसीने छूटेंगे, but try to be, क्योंकि when you will go and appear before the judge, only then you will open up. If you will not, you will not open up for the years together. So try to be, and the judges will accommodate. हमारे दिल्ली हाई कोर्ट के जजेस will accommodate. So I have seen also the my early experiences when I was in T. Hazari, because I started from T. Hazari. When I came to hear one of the judges, he told me, you please go there, वहाँ से थोड़ी experience ले लो. So I started from there. वहाँ पे थोड़ी experience काफी हो गई, तो वहाँ यहाँ से लड़कियाँ आती थी mostly. हमारे वहाँ भी जजेस बैठते थे, तो आगे योर पासवर्ड या डेट चाहिए. मेरे फैमिली की बात है ये. अच्छा, जज कहता था ओके बट जो केस क्या है आप पे, उनको पता ही नहीं है. मतलब इतनी कहते अच्छा आप हाई कोर्ट सुप्रीम कोर्ट से आते हो पर आपने कोई फाइल नहीं पढ़ी है. मतलब everything from I tell everybody when you want to start, please start from the lower court. Please that is your base. अगर आप बेस में नहीं हो तो आप चाहे सुप्रीम कोर्ट तक जाओगे. मैंने खुद देखा है सुप्रीम कोर्ट से आते थे, उनको पता ही नहीं होता था ये क्या है, यू नो. एंड एक बार यहाँ भी मैं कोर्ट में हुई थी, तो कुछ बात हो रही थी, तो जज मेरे को कुछ कह रहा. मैंने कहा जी ये फर्ज है, ये है, क्योंकि देयर आर वेरी निक नेम्स टू द when you go for taking some copies, criminal copies, and you know, so these things you should know. Short is even I told one of the youngsters, आप तो बड़े हो, मतलब मैंने उसको बोला ड्यूटी वकालतनामा. आई नहीं ना वकालतनामा, मैंने कहा ड्यूटी वकालतनामा. अरे वकालतनामा तो क्योंकि हम तो बोलते हैं. तो व्हाट इज वकालतनामा? मैंने कहा पावर ऑफ अटॉर्नी. ओह पावर ऑफ अटॉर्नी को वकालतनामा बोलते हैं. This kind also I have experience with the youngster. So please जो आपके अंग्रेजी वर्ड लैपटॉप्स ये वो अपनी जगह, पर जो बेसिक है, बेसिक आपको पता होगा. जब आप क्रिमिनल कोर्ट का कोई भी रिकॉर्ड नीचे से लाते हो, उधर क्या आपको लिखना पड़ता है वहाँ पे. यहाँ पे आज हम 300 के आज क्लियंट्स को ये भी पता कि कितने पे कितनी टिकट लगती है. Am I right? किसी को नहीं पता है. मेरे वकालतनामे की टिकट लगाओ. अच्छा टिकट लगाने कितनी टिकट लगानी है वो भी तक पता नहीं है लोगों को. सो बेसिक जब तक आप नहीं सीखोगे आपकी जुरिस्डिक्शन ये वो तो बात की बात है. सो प्लीज गो इन द डेप्थ ऑफ दिस. एंड जब आप पूरा नीचे से करोगे तो आप nobody can stop. तो बस मेरी आपसे यही विनती है. बाकी तो टॉपिक जो है वो तो आपको ये बता ही है. थैंक यू वेरी मच.
थैंक यू मैम जी.
मैं हर एक को मेरे पास जो भी आता है, चाहे वो इंटर्न है, आई एम टेलिंग यू एवरीबडी प्लीज देखो, सिर्फ सीनियर का गाउन पहनने से नहीं होता मैं सीनियर बन गया. अगर आप नीचे से जाओगे, मैं भी आज अपने को सीनियर बोलूंगी, मगर मेरे को रियलिटी पता ही नहीं होगा. सिर्फ मेरे पास फाइल है, आई विल गो एंड आर्ग्यू. बट जो बेसिक है वो प्लीज सीखो. बट मैं सबसे बोलती हूँ मेरा फर्स्ट होता है आप बेसिक सीखो.
आपने बड़ा सिंपल और सरल भाषा में हम सब लोगों को एवरी फैक्ट्स पे थोड़ा
रीटा कौर मैडम हमारे बार के मतलब उस जमाने के महिला अधिवक्ता हैं. उनके लिए तो बहुत जोरदार तालियां बनता है. टिकट कितने के लिए लगाना है और क्या कैसे किस तरीके से प्लीडिंग करना है. दिल्ली से भी बाहर ले गए, आपने हमें इलाहाबाद तक ले गए और बाकी जगह के भी बताया. मैं कहूँगा कि हम लोग जो आज अपनी कंसल्टेंसी रूम के जो अधिवक्ताओं की ये कार्यक्रम कर रहे हैं, धीरे धीरे लोगों के मन में आ रहा है. लोग अभी अपने अधिवक्ता बंधुओं ने, महिलाओं ने और कुछ भाइयों ने भी बाहर भी खड़े हैं. मतलब मैं समझ सकता हूँ कि जगह हमारे लिए कम भी होता है. थोड़ा आप लोग भी आ जाए साथ में.
4-5 लोग आ सकते हैं. I mean, we are a group, so हम आप 10 मिनट आती हैं.
इसी क्रम में मैं तो भाई के सिंह जी का साथ ही ले रहा हूँ, मगर हमारे जो दिल्ली उच्च न्यायालय के कुछ चुनिंदा महिला अधिवक्ताओं ने जिन्होंने क्रिमिनल साइड में अच्छे काम किए, मैंने देखा हूँ, मैं स्पेशल प्रोसिक्यूटर रहा हूँ सीबीआई में, मगर जो दिल्ली पुलिस का आपकी जो एक अपनी स्तंभ जो बनाए थे, मेरे क्या लगता है अपनी जस्टिस मुक्ता गुप्ता जी थे, उनके मतलब उसके बाद फिर आपने जज बने, तो उनके बाद इनको भी हम एक उन महिलाओं में देखते हैं कि जो सीनियर एडवोकेट के हिसाब से जो सीनियर मतलब जो क्रिमिनल साइड में प्रैक्टिस करते हैं, और अभी तो रिसेंटली आपने भी डेजिग्नेटेड सीनियर एडवोकेट भी हुए हैं, मगर उससे पहले भी आपके अच्छे काम हैं, मतलब चाहे दिल्ली पुलिस का एरियस का कई सारे मैटर में जो आपकी प्रेजेंटेशन बहुत ही बेहतरीन होता था। तो मैं अभी अनुरोध करूंगा, अभी हमारे बीच में आप हैं, आज अपनी जो सेंटर ऑफ अट्रैक्शन है, आप भी बताएंगे हम लोगों को, सभी अधिवक्ताओं को ये मार्गदर्शन देंगे। इंग्लिश में भी चलेगा, कुछ हिंदी में भी, हम लोग तो भारतीय भाषाओं में जब बात करते हैं कि कुछ हिंदी में भी कह लेते हैं, तो अनुरोध करूंगा, नंदिता राव जी हमारे सीनियर एडवोकेट हैं, आप अपनी बात रखें।
Thank you so much, Mr. Verma, Mr. Singh, Mr. Dhiman, Mr. Palo, Rita Kaur ma'am, Sonia, Akanksha, Latika, my senior from Surya and Company, so many friends and colleagues who are here. First of all, I want to congratulate your group कि आप इस तरह के लेक्चर्स और प्रोग्राम्स रख रहे हैं, क्योंकि मैं भी फर्स्ट जनरेशन लॉयर हूँ और वकालत पढ़ना और वकालत करना दो बहुत अलग चीज़ें हैं। तो आई हैड बीन अ गोल्ड मेडलिस्ट एंड अ टॉपर थ्रू आउट इन लॉ कॉलेज, बट जब मैं हाई कोर्ट जब मैंने स्टार्ट किया प्रैक्टिस डिस्ट्रिक्ट कोर्ट से, सो आई रियलाइज्ड कि आप जज को योर ऑनर या माय लॉर्ड बुलाना भी सीखना पड़ता है। तो पहली बार मैं कोर्ट में गई तो मैं झांक रही थी, तो जज साहब ने मुझे बोला बेटा अंदर आ जाइए। अब उन्होंने बेटा बुलाया तो और बोला आप किस केस में आए हो, तो मैंने बोला अंकल इस केस में आए कोर्ट मास्टर ने मुझे डांटा कि अंकल है तुम्हारे, जज साहब बोला। तो आई रियलाइज कि यूनिवर्सिटी गोल्ड मेडल होना डज नॉट मीन कि आपको प्रैक्टिस में सब कुछ आएगा। सो डोंट बी स्कैर्ड, डोंट बी शाय। आप काम करोगे तो सीखोगे और काम करोगे तो गलतियां भी करोगे, बट एज लॉन्ग एज देयर इज नो मैलिस, देयर इज नो मैलिफाइड कि कुछ छुपाने के लिए आप झूठ बोल रहे हो कोर्ट में, या बिना पढ़े आप गलत सबमिशन देके आ गए ये सोचे बिना कि क्लाइंट को क्या नुकसान होगा, तो ये गलत बात है, ये गंदी बात है। लेकिन अपनी पूरी मेहनत से और सच्चे मन से अगर आपने कोई गलती की हो तो उस पर कोई हंस भी रहा हो तो आपको शर्मिंदा होने की जरूरत नहीं है, क्योंकि शाइनेस में क्या है, आप कुछ सीख नहीं पाओगे। तो नाउ विदाउट मच अडू लेट मी कम ऑन द टॉपिक, बिकॉज फ्राइडे है एंड सबको जाना है ऑलमोस्ट एट 5 o'clock। आज का टॉपिक है क्रिमिनल रिट्स एंड क्रिमिनल अपील्स। सो फर्स्ट ऑफ ऑल मेरे दोनों कोलीग्स ने बहुत अच्छा आपको बताया कि किस तरह की क्रिमिनल रिट्स होती हैं, and also that we have to be cautious that through us the clients do not abuse the court jurisdiction. Now I want to tell you very practically, but before telling you I want to ask you, आप लोगों में से कितनों ने क्रिमिनल रिट फाइल की है? प्लीज रेज योर हैंड्स। Come on. Susan, we'll start with you. Just tell us what criminal writ have you filed?
यस मैम, मैंने हैबियस कॉर्पस में भी की है, मैंने मैंडेबस में भी की है कि डायरेक्टली टू द एसएचओ टू प्रोवाइड द पुलिस सिक्योरिटी टू द कपल्स who are newly married and without the consent of the family members.
And habeas corpus was for?
एक चाइल्ड की कस्टडी के लिए डिटेन इलीगली तो प्रोड्यूस द बिफोर ऑनरेबल कोर्ट एंड टेक द सम ओपिनियन ऑफ द चाइल्ड।
Wonderful. आपका नाम सर?
जयशंकर।
जयशंकर जी। आकांक्षा, you had also raised your hand. Sonia? Sorry.
अनुष्का।
Ma'am, many in fact parole, furlough, or washing, and
Can you share with us what is parole and furlough?
yeah, sure. So parole and furlough are entitlements given to the inmates. So जैसे कैदी होते हैं तिहाड़ जेल में, जिसकी सेंटेंस हो जाती है, जो कन्विक्ट होते हैं, not under trial prisoners, उनको 2 एंटाइटलमेंट मिलती है रिलीज होने के लिए, एक होती है पेरोल एंड एक होती है फरलो। सो पेरोल और फरलो में बेसिक डिफरेंस होता है। पेरोल जो होती है वो 1 साल बाद मिलती है एक इनमेट को। फरलो जो होती है कन्विक्शन की कुछ टाइम सम मंथ्स बाद मिलनी शुरू हो जाती है। जो पेरोल और फरलो होती है, पेरोल इज बेसिकली फॉर अ लॉन्गर एक्सटेंशन। वी कैन आस्क द कोर्ट कि अगर कोई ज़्यादा इमरजेंसी है, कोई ज़्यादा कोई प्रॉब्लम, लंबी प्रॉब्लम हो रही है, तो
डेथ है,
राइट, सो 3 मंथ्स के लिए, 2 मंथ्स के लिए हम एक पेरोल ले सकते हैं। एक इमरजेंसी पेरोल की कैटेगरी भी होती है कि कुछ बहुत बड़ी प्रॉब्लम होगी तो वी कैन फाइल एन इमरजेंसी पेरोल ऑल्सो। और फरलो होती है, फरलो जो होती है वो अपनी कुछ 3 वीक्स की ही होती है जो हमें मिलती है इनमेट को। फरलो एक राइट की तरह भी होती है जो एक इनमेट को एक्सटेंड होती है। फरलो कैन ऑल्सो बी गिवन जैसे कि सोशल टाइज मेंटेन करना होता है एक इनमेट को, सो फरलो कैन बी गिवन ऑन दिस
वेरी गुड, थैंक यू।
Basically in the category of quashing only from the defense side, whether it's a settlement or a questioned FIR question. So my first thought was like filing and maintainability. But before even if I would get a clarity on it, ma'am said that the client should not abuse the law. Sometimes what happens is that even if it is not maintainable, the people come to you for FIR quashing laga do ji. Are you getting my point? And under that circumstances you feel कि क्या करें कि मतलब whether it's maintainable or not maintainable. It is also used as like the writ is like misuse or abuse or the possibility of the defense.
So tell us, when can you file a contested quashing? When can you file for quashing of an FIR according to you?
Ma'am, the charge sheet has been filed and almost 4-5 years the supplementary charge sheet is not there and the person is already in column 12 and wrongly they were called for from the district court, summoned. They were summoned on that this thing and then discharged. But actually when there are no charges and you're already on
There was no need to file.
there was
Well said.
well said. So this is one circumstances, but eventually we had to fight.
Excellent. So
Sometimes the council has to strategically work.
yes. So half my work is done already. So basically habeas corpus. Now it is very interesting. Mr. Dhiman ने आप लोगों को बताया habeas corpus कब फाइल होती है जब पुलिस ने what we normally think जब हम कॉलेज में होते हैं that when somebody is detained against the rule of law. Now will somebody tell me why is a writ maintainable? कौन सा fundamental right है ये हमारा? Article, excellent, brilliant. So Article 21 says that your life and liberty cannot be taken away contrary to the law. What is the law? It is CRPC, it is UAPA, it is PMLA. So only if your detention is according to the procedure prescribed by the law, only then you can be detained. And suppose you are detained without the procedure prescribed by law. Say for example, the police comes to my house, picks me up and puts me in the jail. And there is no FIR registered against me. Will you file bail or will you file habeas corpus? Habeas corpus. So it's that simple, nothing complicated. So habeas corpus is filed when your arrest or detention by any authority, be it income tax, be it anybody, is not in accordance with procedure prescribed by law. Now protection. Our colleague Mr. Jaishankar told us, a couple, sometimes what happens, parents are not happy that the girl has married or has got into a relationship in another religion, another caste, same-sex relationship. So how is the writ maintainable? Can somebody tell me? Can somebody tell me?
They have a threat with the family members.
So who is the writ maintainable? Can we file it against father or mother saying no? Against the state. So what right do we have from the state? Right of protection of our life. So the parents, what do we come to the court to say? Effectively the parents get restrained. But actually, what are we saying? We are saying state, I have not done anything illegal. I have want to marry somebody from a different religion, caste. This may not be acceptable to my parents, but they should not be allowed to harm my life or liberty against the. So there is no procedure that our parents can lock us in the room, or they can do a honor killing, or they can beat us up. And what is the duty of the state?
To protect.
To protect us. So SHO gets done. So all this is coming from Article 21, protection of our fundamental rights. So we have covered two writs, habeas corpus and protection. Now, a very interesting thing Mr. Jayashankar told us. He filed a habeas corpus when the father had kept the child without getting an order from the guardians and wards court. So this is a very interesting jurisdiction. Is the father a private party? Yes. So how is a writ maintainable? Because try forget the state for a moment. Who has kept you in illegal detention? So habeas corpus is a unique writ. That be it a police officer or be it a private person. Suppose my neighbor locks me in the house. Anybody. So suppose the parents forcibly keep somebody's wife. She's run away and got married and they kidnap her and lock her again. Or if it is a child. But children, this is a very delicate jurisdiction because family court has the jurisdiction. Both parents are natural guardians. In instances, the court tells the mother, please go to the family court and get custody. But where the child was in the custody of the mother and in a clandestine manner, बच्चा school गया वहाँ से बच्चा उठा लिया. Not that the mother leaves the matrimonial home and then files in habeas corpus कि मेरे बच्चे को दीजिए. Are you understanding the difference between the two situations? If the child was naturally in the custody of the mother, अगर बच्चा mother की custody में था जब separation हो गई थी और father ने छुप के बच्चे को kidnap कर लिया, तो kidnapping होती नहीं है mother and father के बीच में. There the judge says, okay, habeas, बच्चे को दिखाइए, लाइए, restore status quo and tells the father go to an FIR is registered, but the complainant and the accused person settle. Okay? Now, who knows what is a compoundable matter and what is a non-compoundable? Okay, please share.
Earlier the CRPC
Let him try. He's a young
मैम कंपाउंडेबल मैटर्स जो होते हैं वो कोर्ट के बाद सेटल कर सकते हैं और जो नॉन कंपाउंडेबल होते हैं जो कोर्ट के बाद सेटलमेंट नहीं कर सकते.
Excellent.
सेक्शन 89 ऑफ सीपीसी मैं आर्बिट्रेशन कंसीडरेशन के लिए.
So now this is very good. So section 320 CRPC used to have it in BNSS. I'm as ignorant as everybody else, but there's a comparative chart luckily, so we can all. So certain offences which are not that serious or which are basically private in nature, such as cheating. Somebody has taken my money and not returned it. So that does not really harm, though it harms society because it's a criminal offence, but though it is an offence in rem, meaning any crime does harm the public because today you've cheated me, today, tomorrow you'll cheat her, day after you'll cheat the other person. And if each person keeps settling with you, you will become a nuisance. But nonetheless, in some instances, it is a private sort of an offence. So there are certain offences which are listed under section 320 CRPC and the corresponding provision under BNSS, which are compoundable. So there's a judgment of Gyan Singh, and following Gyan Singh there are several other judgments which say that offences which are basically private in nature, only basically harm the complainant, can be settled between the two parties. So where they are compoundable, you can move an application in the trial court and get the offence compounded. But where they are not compoundable or where you want the FIR quashed, there you file an MOU before the High Court and say, both of us have agreed, please quash this matter. Now suppose it is a 302, murder, or it's 376, rape. So will the court quash it?
No.
Why not?
Seriousness of the
Seriousness.
Gravity of the offence.
And also, because
It is against the state also.
not just against the state. This can become a playground for rich people. You kill a poor person, you give the victim money, and you get the quashing done. So tomorrow you will murder somebody else. So there are certain offences in Gyan Singh which are serious. Now some offences of 376 have been quashed where it was consent was taken by fraud. These are not where the complainant is not alleging that there was force used. But she says, I gave my consent on promise to marriage, and later she, for some reason, has forgiven the man. So in these instances, the court feels, okay, now this has moved from public to private and quashes it. So this is called consent quashing under 482 and now the new provision under BNSS. Then there is contested quashing, where you come to the High Court and you say that this FIR which is registered against me, it should be quashed. Why? Can someone tell
False
me?
implication, falsely implicated.
How? How do you say falsely implicated? How do you prove it? You have an alibi. You have watertight proof that you have an air ticket, you have a hotel thing, you are seen in CCTV. मैं बॉम्बे में था. Allegation है कि जी दिल्ली में आके इसने मुझे छुरा भोंक दिया. So do you have to face the whole trial? No judge will tell you कि ये तो आपका defense evidence है, because you have watertight proof that you were climbing a train in Chhatrapati Shivaji station on that date, that time, when the allegation. So, but mostly contested quashing happens when reading of the FIR, believing it to be 100% true, no cognizable offence is made out. Now, who will tell me what is a cognizable offence? Come on, try. Don't be shy. अभी मैंने तो जज को अंकल बोल दिया और आज 20 साल बाद मैं सीनियर बन गई. इसमें क्या गलती है?
मैम जिसमें पुलिस विदाउट वारंट अरेस्ट कर सकती है.
नहीं. Cognizable meaning जो allegations हैं, they form an offence under the criminal procedure. Now BNS, first IPC, or PMLA or UPA. For example, if I go to the police station and I say that, what's your name? Ashutosh. So I say that, you know, Ashutosh Mishra, I want to talk to him and he's 354, outraging the modesty of a lady, that Ms. Rao wanted to talk to Mr. Mishra and Mr. Mishra has refused to talk to her. Can Mr. Mishra come in a contested quashing? Yes. Why? Who will read 354 CRPC? Come on, you take it out on your phone. IPC. 354 में क्या है? Ingredients क्या है? So sections लिखे होते हैं कि ये section में ये facts offense बनाती है. तब आप section पढ़िए. That is why our seniors always used to tell us, and I will tell all of you colleagues, always read the Bare Act from cover to cover, from definition to repeal clauses. Keep the manual next to you at night and make it your habit. Every day before sleeping, read 3 sections of Evidence Act, 3 sections of BNSS, 3 sections of BNS. After 5 years, आपको पूरा act याद हो जाएगा, and you will understand its scheme. And then it will come to you organically. Now you read 354.
Section 354 reads as assault or criminal force to woman with intent to outrage her modesty. Whosoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outraging her modesty shall be punished with imprisonment of either description for a term which shall not be less than 1 year but which may extend to 5 years and shall also be liable to fine.
Okay, thank you. So now here, what are the key ingredients? Assault or use of criminal force with the intent. So suppose by chance I just push it. No. Mr. Singh, or suppose I, with the intent to outrage his modesty, a police court, can he register 354 against me?
No.
Why?
No.
Because he is not a woman. So one, it has to be a woman. Secondly, by refusing to go for to talk to me. Has he assaulted me? No. Has he outraged my modesty? Did he have that intention? No, he was saving his own modesty. Bhaiya, mujhe baat nahi karni. You're understanding what I'm saying? So he can come for quashing. But suppose it is the case that he pulled my coat and pushed me, then can he come for quashing? No. He has to undergo the investigation, get the CCTV. Are you understanding the difference? Suppose I make an allegation that somebody, when I was going out of the court premises, pulled my coat, pushed me on my chest and made me fall down. I may have written it falsely. But can you file quashing unless he can show by CCTV कि भाई मैं तो 30,000 ही में था? No, because the allegations make out the offence. Then he has to wait for CCTV, 5 witnesses. तू आजा यार मैंने तो किया नहीं मैं तो बात you're understanding what I'm saying? Then there are 164 statements and then he gets discharged. So the difference between quashing and discharge is FIR makes out the allegations or FIR does not make out the allegations. You have a watertight proof of alibi or you have a word of mouth proof of alibi. So contested quashing, in what circumstances you can file, you have to read the FIR carefully. And then you have to, many cases of forgery, if you read the provisions of forgery, you will find forgery is not made out, only cheating is made. So as a lawyer, always put in that extra effort. You can also file a writ petition for transfer of investigation, where you can show, suppose the IO sends you a message that you give me this, can you come to the court seeking transfer of investigation? Yes. Why? Again, Article 20. Fair investigation. So you have a right to a fair investigation. Or suppose you go to the police station and somebody tells you, oh, you are of this caste, you are of this religion, you people are like this, we'll fix you. Can you come for transfer of investigation? Why? Because there is a presumption of bias. इसको पहले ही लगता है मैं चोर हूँ. वो fair investigation and there are judgments. Bias has to be your perception. That after listening to this, do I feel it can be fair? Not objectively. Maybe I have just said it gusse mein, but I'll be fair. But once I have lost faith, then there is a right to transfer of investigation. Parole Farno, Mr. Arora very nicely explained to us. When you are under trial, you have a right to bail. Once you get convicted and your appeal is disposed of, till your appeal is pending, you have a right to suspension of sentence. Once all your appeals are disposed of, आपको 4-5 साल की सजा मिलेगी. Then क्यों आपको parole का right है and why a writ? Please tell me. Writ means what? Fundamental right. Parole means you are going out for a short while. Now remember, what did she say? Some reason has to be there. Family member बीमार है, किसी की death हो गई है, कोई emergency property बेचनी है. So right to life includes right to dignity. And dignity includes my mother has died, my father has died. So this parole comes from jail rules. This is not a right given to you by the criminal manual. This is a right given to you by fundamental right by the judgments of Supreme Court. That just because you're convicted of an offense, that doesn't mean that society, because we are a reformative. So can you reform somebody if you are as cruel to him as he has been? That if your father has died, we will not even let you go and give him the last rites. Will you improve? No. Or will you become filled with bitterness? You get my point? But if society is kind to you, then you will feel, look, I did such a bad thing, but still I could come out. So Supreme Court has given this right that even though all your appeals are gone, you are convicted, you have a right to, these are called remissions. But you have to show good behavior in jail. ये नहीं कि you are as bad, you're kicking people, you're throwing the food, you're beating people in the jail. No, then you're not reformed. So you can file, this is under the jail rules. So if a convict comes to you, you will be wondering, अरे यार ये parole कहाँ है, parole कहाँ है? एक तो गूगल बाबा आ गए हैं, आप गूगल करो, आपको सब कुछ बता देंगे. हमारे टाइम पे we had to come to consultation room, wait on the corner, see यार कोई सीनियर जब 10 लोग नहीं देख रहे हैं तब उनसे चुपके से पूछने सर ये पेरोल कहाँ से फाइल होता है. तो ये जेल रूल से फाइल होता है, ठीक है. Now there are two new writs. This is the end of writs. Then I'll quickly cover criminal appeals. Supreme Court, though this was our fundamental right under Article 22. So, do I have a volunteer to read Article 22? Come, since Mr. Mishra, you've been the object of this meeting. So, now you can challenge a remand order in a writ. So, does anybody know what a remand order is? Of the people who have not spoken, what is a remand order? So basically, what does the criminal law do? Criminal law starts with registration of FIR, first information report. Then, in certain offences, police has the right to arrest. उन्होंने आपको arrest कर लिया. Within 24 hours, they cannot file the charge sheet. What are they obliged to do? Produce you magistrate. When they produce you before the magistrate, magistrate will ask, हाँ भाई इसका क्या करना? Should we leave him? Then they can say, no, we need to investigate. We need him. Need him for what? We're taking him to the spot, doing this, doing that. So they ask for remand to police custody. Or if they don't need him for investigation, remand to judicial custody, meaning jail. Yeah, jail. That means he's in custody of the magistrate, judiciary. Otherwise, he's in custody of the police. Now, you read now Article 22. For the YouTube people, read it in the mic. 22(1) because we are short of time.
Article 22, protection against arrest and detention in certain cases. First, no person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice.
Very good. So, what does, अभी तक we have been focusing on Article 21. अब Article 21 से हम आ गए हैं Article 22 पे. What does Article 22 say? Two things have been said. Number one, when you are arrested, you have to be informed about the grounds of arrest. And number two, you have a right to be defended by a lawyer. So in your arrest memo, they have to write that there are other rights under CRPC. You have to be, one family member has to be informed. So Supreme Court in the matter of Prabir Purkayas and in the matter of Pankaj Bansal and now a lot of judgments has said this information has to be given in writing. Why? Because police में से भी हमने इसको बताया था. How to prove? It's a two-to manner. So give it in writing so that there is watertight proof. And today you can inform by WhatsApp, by email, by, So if Article 22 is violated, that means the arrest is only improper. So then the remand is improper. Or suppose, for example, in the case that I told you all, where it's a bailable offense, बिना देखे magistrate ने भेज दिया remand. Do I have to file bail? No, I can challenge it in a writ. I had a right to bail. Or where it is a case like this, I am sitting, of course I can file quashing also. But I can also challenge the remand order. Actually, we should be able to file habeas. Because the remand order is valid in law. But because it's a judicial order, and generally habeas is against an administrative action. So when the police catches you, you can file habeas. But once the remand order is there, you have to challenge it in a writ that this is perverse. Because generally writ does not lie against a order of judicial. Okay? Then we come to bail. Arnab Goswami's judgment of the Supreme Court tells you in what circumstances. Generally when we file 482, the judge says, I will not give no coercive steps of anticipatory bail dali if you've not been arrested. But Arnab Goswami's judgment, and I urge you all, please read it, it says, like in the case which we cited, where the allegations are so perverse, on the face of it koi offense nahi banta. There you can file, even in a writ, you can get the, in fact it says, the court should give protection. You understand my point? So, this is a rare circumstance. Not in every case can you say, "मैं bail में नहीं जाऊँगा." Why? Because as Mr. Deeman told you, when there is an alternate remedy, you have to pursue the alternate remedy. But where the case is so perverse and so glaring, there you can pursue a writ remedy because it's manifestly arbitrary. Okay? So these are the exceptions. Now very quickly, unless you people are exhausted, then we can end here. Otherwise, if you can give 5-7 minutes, I will tell you about criminal appeals. Okay. So now criminal appeals. Now, what is an appeal? What is a writ? Writ में क्या है? Procedural violation. You are understanding? Arrest गलत कर लिया, गलत FIR register कर दी, गलत detention कर दी. So what is the authority violating? The procedure. So you have to have mastery of BNSS. First it was of CRPC. Whereas appeal क्या है? You are challenging an order of the court, conviction. You are understanding what I am saying? So, आपके खिलाफ पहले क्या है? What is the criminal procedure? FIR is registered. You are arrested. You are produced before the magistrate. Either you are sent in police custody or you are sent in judicial custody. Within 90 days, investigation should be completed. If it is not completed, you get a right to bail. Anyway, investigation is completed. Charge sheet is filed. You get the copy of the charge sheet. You argue for discharge. If you are discharged, well and good, you are free. If you are not discharged, you can file a revision or you can come in a 482 to the High Court. So you have both options. Now where you are not discharged, आपके against trial चलता है. What is the reason discharge का? Very quickly I will tell you. जब quashing का क्या था? FIR पढ़ने से आपके खिलाफ कोई offense नहीं बनता. Discharge का क्या है? पूरी इन्वेस्टिगेशन के बाद. दैट मीन्स जब मैंने एलिगेशन लगाई कि जी मेरा कोट फाड़ दिया, मुझे गलत जगह पे धक्का दिया, लेकिन इन्वेस्टिगेशन के दौरान सीसीटीवी आ गई, सो क्वेश्चन नहीं हो पाई, लेकिन सीसीटीवी में साफ दिख रहा है कि दूर से खड़े होकर इन्होंने मेरे से बात की, मुझे टच नहीं किया, मुझे कुछ नहीं किया. उसमें ट्रायल चलेगा या ये डिस्चार्ज होगी. So quashing is जहाँ FIR में allegation से केस नहीं बनता, discharge is जहाँ investigation के बाद अगर आप हर 161 के statement को CCTV सबको सच मानते हुए prove नहीं होता, beyond reasonable doubt, okay, then you get discharge, then आपका trial चलता है. So trial में क्या होता है? The witness has to come in the witness box. Because the 161 statement is not admissible. Why is it not admissible?
It can be coercion or
excellent. We are not free. I am in custody or I am reporting to authority which has power. The power is different. So in its wisdom, इतना पुराना बना हुआ code है. But what उस time our constitution also wasn't there. But still this protection was given. Now the protection has to be higher. During colonial time, I had no right, constitutional right to liberty. Now I have a constitutional right to liberty. So my rights have to be higher, not lower. So, where was I? I forgot. Okay, so 161 statement is not admissible. So the witness has to come into the box. He will give his statement, you will cross-examine. All the evidence will be there, arguments will be there, then you are convicted. Conviction के बाद आप अपील फाइल करेंगे. So अपील और रिट में क्या फर्क है? रिट में आप फंडामेंटल राइट का वायलेशन दिखाते हैं, प्रोसीजरल वायलेशन की ड्यू प्रोसेस ऑफ लॉ से मुझे नहीं ट्रीट किया जा रहा, मेरी लाइफ और लिबर्टी ली जा रही है. अपील में आप एविडेंशियरी लॉ का वायलेशन दिखाते हैं. यू अंडरस्टैंडिंग माय पॉइंट? वहां आप प्रोसीजरल लॉ का दिखाते हैं बिकॉज आर्टिकल 21 का या 22 का वायलेशन है. यहां आपने क्या दिखाना है? यहां आपने दिखाना है कि द विटनेस केम इनटू द बॉक्स एंड सेड, मैंने सुना था कि फला फला ने फला फला का मर्डर कर दिया. एंड जज ने बोला कि विटनेस ने बोला कि उसने सुना था, तो ये है. नाउ कैन यू बी कन्विक्टेड ऑन दिस? Why? Yes. So what is your first ground in appeal? The conviction is bad in law because it is on the basis of hearsay evidence. So I am just giving you a very extreme illustration. Okay, for example, WhatsApp कॉल की दूसरे फोन से वीडियो बनी है. Is that admissible in evidence?
With the 65B affidavit. 65.
But 65B affidavit saying what? कि इस वीडियो से ये बनी है. Then you have to send it to FSM, so the continuity. So suppose that is not there. Now you have to go to IP Act. What will your ground of appeal be? The procedure under IP Act is not. So reliance on this is not bad. Why? Because it is not proved correctly. So you're understanding the difference between a writ and an appeal. So in an appeal, you have to read the judgments. You have to underline all the findings of fact. Then you have to read the evidence. And you have to see, has the evidence been proved as per the Evidence Act, as per the Information Technology Act, as per the law. Now, for example, suppose a wife comes and something told in confidence by the husband, she discloses कि जी husband ने मेरे को ये बोला था. या the public prosecutor or the judge forces her कि आप बताइए नहीं तो आपके खिलाफ contempt डालेंगे. She says हाँ जी उन्होंने मेरे को बोला था कि ये. Is that admissible?
No.
Because it's a privilege. So that will be a ground. This cannot be relied on. So in an appeal, you have to take out all the grounds that violate the Evidence Act. Now, where all the evidence is as per Evidence Act, but what is the onus of proof? It has to be beyond reasonable, sorry, not onus of proof, the level of proof. So you can argue in the appeal that, okay, these witnesses have said this, but they were inimical to me. So, veracity of the evidence. So, if the evidence is correctly proved, then we go on to veracity. That ये witness ने 4 और जगह झूठ बोला है, ये habitual witness है, 10 cases पुलिस में ये वहाँ खड़ा हुआ था कि हाँ जी drugs से बरामद हुए मैंने देखा. So how come this fellow is always there where police is and he's been shown as a chance witness? So you are challenging his credibility. Or suppose I am a witness of a sexual offense, but first in my 164 I have said something. In my court thing I am improving. उसने वो भी किया. So my contradictory statement. So you challenge the veracity of the witness in the appeal. Then lastly, even if veracity is correct, it has to be proved beyond reasonable doubt. Suppose सारी बातें सुन के जज को फिर भी लगता है कि दोनों चीजें हो सकती हैं. There he has to give the benefit of doubt to accused. So where is 50-50%? So that ground of appeal, where there are two possibilities, whereas in civil law, preponderance of probability, ऐसा हुआ होगा, but जहां जज को लगता है ऐसा हुआ होगा, but 1% ऐसा भी हो सकता है, reasonable, not unreasonable doubt कि लाश पड़ी है, उसके ऊपर खून भी है, उसके कपड़े भी प्रूव हो गए, उसके हाथों में भी था, CCTV भी है, there you can't see, it's, but where there's a reasonable doubt that this fellow, he has no criminal antecedents, he has never done anything to any lady, he was just going, this is his normal path, no question of that lady being over there, and these allegations are there. So where there is a reasonable doubt, a reasonable man or woman will have that doubt, there the benefit has to be given to the accused. Even if I want to give it to the complainant, under law I have to give it to accused. Why? Because the most important right you are taking away, right to liberty. You know, we take it so casually. I mean, I as a government counsel also maybe